So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
Yes.
Whoa.
So that Kate, I'll let you do the talking.
No, he did his time and he got out, and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
so he was
charged with
murder twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, even threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA. But I don't have the documents, which is why I can't present them. If there's an ICA hold, he's ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say. But if I get the documents...
Interstate compact agreement.
I understand. May I speak, Your Honor?
Of course.
Okay. We talking about the probation, I'm at the probation, the GPS, curfew-wise, my judge knows all that was going on. So he knows every information why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why, though.
I understand that.
That's why he overlooked. He said, okay, it's fine. He said it was fine.
Quick question: is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
Mm-hmm. It's very recent.
So they've not heard. Okay, and then so there's not been a hearing on that yet, right?
No. But that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up, guys. I took the plea deal.
What are you on probation for?
The armed robbery, conspiracy to commit armed robbery. I did 5.5 years. Came home off lifetime probation. And to continue what I'm saying, so I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court and got locked up. So there's no flight risk in this.
This is where the hearing takes a sharp turn. The prosecutor isn't just arguing that he missed curfew. They're building a pattern. In bond hearings, judges don't need proof beyond a reasonable doubt. They're looking at risk. And once words like weapon, children, and multiple violations enter the room, the odds of walking out drop fast. What do you guys think? Should repeated curfew violations outweigh the fact that he kept showing up to court?
However, if I've been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew.
Yes.
And you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time I forgot what time it had as, but I had started my new job because I got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, we've been working. I said, yes, I have documentation of new work. So I'll show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. Obviously, I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus, that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor, he's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for if since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Texas Code of Criminal Procedure 17.03. NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/2021. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, that you're supposed to be out there with a halo over your head.
Now this is the defense's strongest moment so far. He's basically saying, if I were really a flight risk, why would I keep turning myself in? That's actually a powerful argument in court. Judges love accountability. But notice the clash happening here. The defendant sees compliance as showing up to court, while the judge sees compliance as following every single condition perfectly. 2 completely different definitions of responsibility.
And yet, you pick up an aggravated assault with a deadly weapon, where allegedly a gun is pointed at kids. I mean, the way your mannerisms.
I would say something, y'all. That's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. Mr. Thurman, you scare me, man.
Can I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful for safety. If I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond, and I have not been into this no courtroom, but or the jump shoot, I should say. Your courtroom, anybody's
You
courtroom.
want me to reward you for being?
I'm saying, but you say you're in fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I have not been into any trouble. whatsoever. I've been squeaky clean. Just I bond it out.
And Your Honor, to
You
your,
don't get rewarded for being a good person out there. You know what I mean?
I
You're
understand.
supposed to be like that anyways.
I understand that wholeheartedly, Your Honor. I'm just saying, when you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you, that should show you some type of sign. Like, okay, he's not been doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, you know, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want someone out there to suffer because we let you out. I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
And Your Honor, you keep saying violate. Like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from other jobs, so I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard for any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying it.
And there it is, the detail that changes the entire emotional temperature of the courtroom. Allegations involving children instantly raise the stakes. Even though these are still allegations, judges tend to become extremely cautious when public safety is tied to minors. Watch the judge's body language here. He's already mentally leaning toward denial before the defendant even responds.
I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear. But I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you say, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to what you're just reading on that police report. It's always going to be video cameras and house ring cameras, body footage. It's going to be a lot more other things that you're not going to be able to read off a police report. It's just understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you on. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
Really, I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, Sean. Y'all say you tell me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really, for a whole year, I've been out. And they just not issue a warrant for me just now, recently, and I come to turn myself in, and I'm a threat to society. And people, you fear me for what? From turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all a threat. You can let go of me, sir.
Stop.
You can let go of me.
You do not tell me how to do my job.
You can let go of me. Grab my arm too tight.
Guys, relax.
Arm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grab me. I said you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him why she let me go a little bit, sir. That's all I said.
Come on. Open the door.
That's all I said. When you make somebody cuss you out everything. You said I'm all tight because of love.
So he already waived. So if
He did.
holds it, then it's
Just, I can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated. I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much.
It looked like there was
Even, and I'm going to tell you, even if he didn't have those bond violations, I'd still be very hard pressed to even,
No, and I was curious because when you brought it up, it was a little bit older, and so I was wondering why.
are they going to come get him?
I'm not going to get him. I was trying to figure out why now. And they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases, so we're sitting anyways.
Yeah.
He has not? He
No.
said he did.
No, he's not made bond on those cases.
He's been in jail for a year?
No.
He may have, but they revoked the bond.
Ah,
Yes.
So he's sitting there, and I
There you go.
didn't have the heart to tell him right now that the 14 days is not going to apply
Yeah.
because
I gotta do that.
Well,
I will. Really.
I would
I
imagine-
It's
will.
just-
I'll let him know.
I'd imagine it's gonna get resolved because it's one of those. It's a bizarre. So we revoked. Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events because the only thing the court sees is that they revoked
So-
on the probation, which was called.
Please let him know that the 14 days hasn't kicked in, and it will not.
It will not kick in.
Resolves.
Right.
And either he resolves the cases.
So which
Okay.
one does he need to resolve first
Because-
in order for?
Well, for the felon possession of the weapon, there's. Hold on, I don't want to.
This might be the most human moment in the whole hearing. He's not arguing law anymore. He's arguing survival. Employment, probation restrictions, being a felon trying to keep a job. That's real-world pressure colliding with courtroom expectations. But here's the problem. Judges often hear explanations as excuses once violations pile up. Do you think the court is being fair here? Or is the system setting him up to fail?
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been set for jury trial at least
Four
Really?
times.
4 times. 1,
Yeah.
2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6, 2025. But he's held on $55,000 bond for the ag assault and $55,000 for the felon possession. So he has to come up with $110,000 for.
Wait a second. So
So it doesn't matter what you did today.
can't. Even if I gave him a bond today, he would still have to make those bonds.
$110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this
I'll
ag
explain
assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan revoked.
I should
Oh,
say-
no, it doesn't, but we don't know that for sure.
Yeah.
Because there's no notes that reflect why they revoked the bond. It just says, court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay,
It's remand custody violation report, but that's not a revocation. Yeah, because
it's a violation report from Michigan?
no. For me, so remember when I said the newest violation was on November 1st for all the curfew violations?
Mm-hmm. Is that from here?
Technically, that could be the reason why they revoked instead of Michigan. I don't know because I don't have the document. And
Yes.
So,
But he hasn't gone out to Michigan to I guess take care of.
for that
The
one,
current
that one
bound
since
violation.
2023, so it would have predated.
I get
It
you.
takes some time for them to do it, which is why I hate it because they should have waited to file it. But whomever originally had him, well, actually, if he said he was in the courtroom, that happened. Yeah, sheriff's office. So they should have known to wait and file.
I got you. Okay.
Okay, well, I guess reset to track locals. Oh man,
Don't set it to January.
I'm not. When in
So-
December would you like to touch base?
Now my question now is, does it matter for us to touch base if his locals are going to be reset out far out? What's the
Yeah,
point of?
Yeah, we have to,
You
gotta
gotta
keep
do like a plea deal,
Makes sense.
or mid-trial dismissal, because it's Troy Locklear on the one.
So let's do this. Do you see a date for like a pretrial motion or a pretrial setting for them?
Trying to they file a motion.
Highly doubt it,
File a
Judge.
motion. I mean, there's nothing between here and there. Judge Jones, I would be surprised if they set another
Okay.
So if you want to talk to Troy-
18th, 17th of December?
17th of December.
Finner? Is it Troy Finner?
No.
Troy Locklear. So hold on, December 17th.
I'll find out.
Yeah,
All right.
okay.
17th or 18th, whichever one of those days works for you, I'm good by it.
I live in this building, you tell me.
And then if you have any problems with him, we can bring him back out as far as just tracking locals, meaning that just let him know they revoked the bond.
Oh,
And
that's-
essentially, the time here, it's kind of told until he either gets a bond reinstated, post bond, or somehow deals with the case.
Because the bond is set, so if he can come up with the money, he can. But I'll put 17th, and then if you want it sooner, or a couple
Got
days,
you.
let me know.
Sounds
See you
good.
tomorrow for,
Yes, sir.
Okay.
I think
Thank you, Judge.
we are done.
Maybe excuse Judge.
Oh my God.
And Your Honor, I filed dismissal on moves. I emailed.
Come up, Mr. Burrows.
Also, we did the,
Boom. Bond denied. And honestly, you could feel that coming for several minutes. The judge kept repeating one phrase over and over: public safety. Once a judge believes someone is unpredictable, it becomes incredibly hard to reverse that perception. Notice too, the defendant keeps trying to argue logic, while the judge is making a fear-based risk assessment. That disconnect is why this hearing spirals.
I was in the process of appealing this on Friday. I was going back and forth with Nathan.
Appealing.
Appeal for a pizza. And,
Oh, so they denied him?
No, we're almost there. He took the decision, and then this came, so I just, I'm waiting to talk to you. I told him about this on Friday, and he drove straight to the Freakout services. But that's what's going on with that. Just tell you.
So, but I don't understand what you're saying about appealing. What are you?
No, I'm doing a P-tip appeal because he's not necessarily allowed to P-tip what the situation is, so I did.
You mean you're doing a mitigation package?
I already did it. Everything's turned in. I did everything, mitigation packet.
They said yes.
I don't know yet.
Oh, you don't know.
We're going back and forth, and then I stopped that because I literally, I got that report right then and there. I was going back and forth with Nathan on Sunday.
Do you guys have any guidance on Burrows? It looks like he's filed for the diversion program for DWI.
Amanda? Is that
Just whether he's been accepted into the program.
are you Amanda? I'm sorry.
I'm not.
Oh, I'm sorry.
She works for the recovery unit.
Okay.
So I believe that Nathan he was waiting because there was a previous DWI that was filed out of county, and he was waiting to receive the OR from that previous DWI. Because we don't know, it might have been dismissed.
It was dismissed. I gave him the dismissal paperwork, and it was because there was nothing on
But
it.
I still have to know too, so I can take the appropriate action as far as bond condition.
I'm happy to email
Go ahead.
Nathan right now. I think we just received the OR this morning
Where from and when?
from Galveston County. Let me look for the judge.
This case has been open since June, and I'm just now finding out that he had.
I didn't know it either because he thought it was expunged because it says interest adjustments, no evidence for DWI. Basically, it was like he had it was nothing, just got thrown out. So that being said, he said he didn't do anything. That's whatever. That's that. But
Yeah, I think it had been, I think that we are all in agreement that it was dismissed. I think Nathan just wanted the copy of the offense
What
report.
year was it?
1 second, Judge. Yes, Judge, the DWI is from 2019.
Yeah, I probably would have put an interlock on him.
But the reasoning on the dismissal, they put it on there.
And now he's still consuming alcohol, Mike.
That's what I'm saying. He's here to tell you, I don't believe that's the case. He swears up and down he didn't.
I have a scram.
I understand that. And he puts some crazy amount of makeup on him, and the alcohol, it's I gave you the pictures of it also. It's called alcohol what's it called? Hang on. He can explain it to you, but I have it here.
I have pictures of.
The nature of alcohol can be mistaken for alcohol consumption. I know.
I have these pictures. It has no date. It has no.
To give you context to it, I have the dates here. Those are just pictures of the close-up makeup, but he was D-Day.
Okay, this may be one of the wildest explanations you'll ever hear in court. Makeup causing a scram alcohol violation. And to be fair, certain products can trigger false positives. But a reading high enough to compare to multiple drinks? The judge is clearly not buying it. This is another example of credibility becoming everything in court. Once a judge doubts your explanation, every future explanation gets harder to believe.
DJing on those particular dates, and I have it right here because I was trying to get it in the club.
And I guess drinking while DJing, right?
No, he said he wasn't. I mean, you talked to him. I wasn't there. It was DJ Sidney Ray, October 31st at this place, and that was the day in question. And then this is October, this one, I'm sorry,
Okay. So
October 27th.
I have here that you're consuming alcohol. I have here that the consumption is October 26th,
Yeah, that's the, I believe it's
October 30th,
in November 9th.
November 9th. Oh, and October 9th. So
That was, yeah.
I have 4 different events that you're consuming alcohol.
For October 9th, Your Honor, that was whenever you told me to put the scram on, and I put the scram on right after that. And then those other 3 dates.
So you're allegedly consuming alcohol the day I tell you to put it on.
No, he did it, that's the day, and then he put it on. No, that's the violation, we addressed that.
I have a positive for alcohol on the 9th of October.
Nothing was scram, I think.
Yes.
October 26th.
I sent him on 10/9. So Felicia,
Yes, Judge.
so we sent him for a POC test on 10/9 on that time. Did he test positive for alcohol?
Yes, Judge.
Why on earth are we just now getting the violation?
The violation
No.
was already addressed.
That was addressed.
Yes, that violation was already addressed in a previous BVR. They started to put it in that section, that's why I didn't highlight it, but
Can I address that BVR?
yes, and that's when we amended the conditions to put a scram.
Okay, so now we have alcohol consumption as a second violation on top of all this.
For the scram itself.
I've been very grateful for the second chance you gave me. That was from the makeup that I applied to myself, and I was just ignorant to the fact that that would actually set off my scram device, but I have not consumed another alcohol beverage at all. Those are also the days that I was working, I was entertaining, I did not consume another alcohol beverage at all, so I've been very grateful. I'm not stupid, I wouldn't consume another alcohol beverage after you put the scram device. in
Mr.
yourself.
Burrows, I told you at every single stage of this game, do not put anything into your body that could be positive for alcohol. It is your responsibility to know what you can and cannot use. You're old enough to know that actions have consequences.
Yes,
And
sir.
here we are. I've already let you go one time with a positive for alcohol. When I told you not to consume, you literally tested positive on the day that we sent you for the test, and now we have another 3 positives for alcohol.
I don't think that's, that's the part, the other parts, yeah, but the first part, that's not, he didn't test positive.
He tested positive 10/9.
No, that was,
It was a positive urinalysis test, and because of that, we amended the.
And because of that, I amended the conditions. I did not put him in jail. I put the scram on him.
yeah, but we addressed that he didn't go in and like,
I got it.
it's not 2 tests, is what I'm trying to say.
Okay,
You're right.
but he's continuing to consume.
So, yeah.
Stephen,
The scram reports are also in your email. I'm not sure if you picked them, but we got the notice of the records as well for all of those dates.
have you seen that?
I have whatever I was sent yesterday.
That's it.
I'm sorry, Mr. Bros. What am I supposed to do? Just let you go again?
No, sir, I'm not asking to, and I did not consume any alcohol. It was just yes, sir, the products that I put on, and I just was not aware that that was set off that. And it was makeup, sir, that's all it was. I didn't consume an alcohol beverage at all.
That party is 10:31, and I have here 10:26, 10:30, and you're telling me that you put this makeup on November 9th? Is that what you're trying to tell me?
Yes, sir, it's for my TikTok, and I have the videos of it also, sir. I do cosplay, and I just put on those products, and that was the sweat from it. I had no idea that that would actually get inside my blood system and and set that off.
You have levels?
Yes, they're in the scram report.
What is it?
I have.
It's like a peak of 0.08, and then, so,
He's a 0.08.
Yes.
You're telling me that makeup made you a 0.08?
Yes, sir. And those are the days I was at work.
I don't believe it for a second.
I even had
I don't believe it for a second. I'm sorry. A
understand.
0.08 because of makeup?
Yes, sir. I understand. I promise you I have not consumed alcohol at all.
I'm sorry, dude.
I
That's
understand.
it.
Yes, sir. I understand.
With you?
I understand, yes, sir.
Can't possibly believe that makeup is going to make you as intoxicated as having 6 to 8 drinks.